All right, there's a chain of logic that you have to pay attention to when we're talking sovereignty. Okay? Now, I want to emphasize a couple of things here. Wise men are instructed by reason. Okay? Everybody read this okay? That's large enough, right? Wise men are instructed by reason, men of less understanding by experience, the most ignorant by necessity, and the beasts by nature. That was by Cicero in his letter to Atticus. And in order to make this stuff work, you absolutely must be instructed by reason. It's difficult to find cases to support your sovereign point of view. So you have to take what you see, put two and two together, and on your own figure out it's for. Okay? The very first order I ever issued in a case was not my case. The sovereign of the court, the sovereign was in jail. He had moved for habeas corpus in the Superior Court. The Superior Court judges just overruled him, didn't recognize his habeas corpus, which was handwritten because he was in jail. He was being held in jail by the municipal court. So what he did was, by sovereign authority, since he had already created his court with the habeas corpus, Superior Court, he appointed me as a special master in his court. Now, a special master is basically, in this sense, is a judge without the pay. Okay? He gave me blanket authority to do a number of tasks, and so I was going to start performing them. And I started researching the case and so forth, but I filed a copy of the special master appointment. Now, understand that we had no precedent, but according to our research, if he's the sovereign of the court, if it's his court, he can appoint anybody to staff his court, right? You know, if necessary, he could appoint a court jester. Okay? In this case, I'm my own court jester. But that's why I wear the hat. But you see, he appointed me as a special master, and I had the authority to investigate, to take testimony, and so on. So I started working on the case. Well, while I was working on the case, there was a jailhouse rumor that he was going, his case was going to come up for some sort of hearing the following Monday. So I quick did some research as to what we could do there, and again, no precedent. All I knew was that I was a special master of the Superior Court, and I was entitled to conduct hearings. So I went down to the municipal court, and I met with the judge in chambers before he started his court sessions, and I said to him, I understand that you have this case. You know, I requested, and I got a hearing, and I was dressed looking like an attorney, by the way. You know, pinstripe suit, no beard, okay, proper tie, vest. I actually had a vest.
No crown.
No crown, right. Like I was a subject, right? And so I went into chambers, explained to him that I'd been appointed a special master in the Superior Court. I understood that this case was coming up for hearing, and I was here to observe the proceedings. Well, anyway, it got to be a little more fun after that, because the prosecutor came in and started talking about the case ex parte. No, I was there in my capacity. He took one glance. He said, "Oh, fellow attorney, you know." So he's talking to the judge. But he started talking about this case, which is absolutely illegal, of course, for him to do. The judge was no dummy. He said, wait a minute. He says, "This is getting too complicated. We need to go on the record." He cut it off, okay? But of course, if we had chosen, we could have prosecuted the prosecutor for that. Anyhow, we didn't. But we went out into the courtroom. When he called the case, I stood up, and on my left was the prosecutor. On my right was the public defender that had been appointed that he did not want, that the defendant did not want. And so when it came my turn to speak, and I'll tell you in retrospect, I was very lucky. I had a very intelligent judge up there. He was far better educated than most municipal court judges. But at the time, I didn't know that. And so he said to me, he says, what do you want me to do? Well, I'm a special master in the court. I cannot instruct him what I want him to do as an individual. So I spoke regal language. Now you understand, in regal language, the king never orders anything, right? He only wishes for things. In regal language, you speak in the third person. The king never says I. He himself refers to the king when he means himself. Okay? So and since I was on borrowed authority, because I was not in sovereign capacity, I was in a master of the court capacity. So I said to him, I am William Thornton, and I've been appointed a special master in the Superior Court of the State of California, and I am here to observe the proceedings in this municipal court case, and I'm here and now declaring the Superior Court of the State of California open and in session. And so then we started talking back and forth a little bit, and I said that it appeared that there were some common law rights that were at stake here, and the judge immediately informed me that, well, the common law had no standing in this court. And so I informed him that I said yes. I said, you're absolutely right, Your Honor. I agree that it has no standing. However, in Miranda versus Arizona, the court said that where substantive rights are at stake, there shall not be any rules that would abrogate them. Okay? So he agreed. That's right. He knew the Miranda case. Okay? Everybody's heard that read your rights case. Well, that's a nice part of the case, but the real thing about the case is that they can't make any rules either for or against your rights. Rights stand on their own. So he acknowledged that. We're dealing with substantive rights. So we paused for a moment. This is a little war story here. We paused for a moment, collecting our thoughts, I guess, and the prosecutor stood up, and she said, Your Honor, who is this man? I don't know who he is. I don't know what he's doing here. The judge just stared her down. He didn't say anything. She finally sat down, frustrated. And then he turned back to me, and he started speaking, and what he said had absolutely nothing to do with what she had to say. It was the greatest act of discourtesy I've ever seen a judge commit against a prosecutor. You know, I mean, normally these folks are very close. Well, my knees were shaking up until that point, and then I realized I had something here. Here I am, a third-party invader, and he's giving me full attention. Okay? Something's going on. I must have figured some of my theory was right here. So I proceeded. And he said, so he asked me, what is it that you want me to do? And I said, well, it is the wish of the Superior Court that the municipal court release jurisdiction of this matter to the Superior Court until such time as the issues in the Superior Court are settled. And he said, I will do that if you will give me the order in writing. Now I went personal in my conversation. Back to me. I said, well, I came prepared with half an order, Your Honor. I said, I didn't know how things would go, but if you will recess the case, I will complete the order and be ready when you recall the case. And he said, okay, and so that's what he did. He recessed it. And then I rushed all over, I wrote it out real fast, and then I rushed all over finding a copy machine, getting copies made, and came back. So when later on in the day, when he called the case, I then gave it to the marshal. He passed it up to the judge. The judge read it into the record, and then he ordered the order to be filed into the case. And then that was the end of that session that day. Okay? So that's how we did it. That was sovereignty in action. But the thing that I got to understand is that we arrived at this purely because of a reasoning process. Okay? Purely because of that. We said if A is true and B is true, it must follow we got the authority. Now, not everybody likes to think, and this is tough. How many times have you heard somebody say, do you have an example of this? Have you ever, can you show me any case law? You ever heard anybody say, you don't have anything unless you got a case to support it? I've heard that. Okay? Not true. Not true. There are priorities. The highest law is the common law. Okay? The Constitution is under the common law. The Constitution recognizes the common law too. And you can see in the Seventh Amendment, when you have a case at law, no decision by a jury is reviewable in any court. That's what it says right in the Constitution, in the Seventh Amendment, other than by the rules of the common law. And what do the rules of the common law say? Well, basically what it says is that if a jury makes a decision, the only way you can beat that is with another jury. But the Supreme Court has no authority to touch it. Now, if you're wondering why judges cancel out certain juries' decisions, it's because those were not real juries. Those were advisory juries. That's another situation. Yes, sir.
Bill, a question. Can legal maxims which are based upon the common law be used?
If you decree them so, sure. See, you have to decree it. Make it the law of the case, and you betcha. Yeah. Right. As a matter of fact, anything. I have a law, some of you have heard about this already. I have a law that is my own creation. And that is that nobody is allowed to wear pink shoes in my presence. And I take this very seriously because there's a death penalty associated with the violation of that law. Okay? Now, I have to acknowledge, because of the impact of reality, I have to acknowledge that it would be very difficult if the defense were to invoke a jury, it would be difficult for me to get a jury to accept that law. Okay? But they don't understand my background. Okay, I think it's a reasonable law, but I acknowledge that most jurors would not find it reasonable. So what most jurors would do, because remember, the job of a juror is twofold. They judge the facts, right? They also judge the law. And if they don't like the law, they can throw it out. Jury nullification, right? So the probability is, I have yet to achieve a single conviction, by the way. But, and that may have something to do with it. But now you turn it around. Let's say I have another law, which is that basically the law operates this way. If I'm walking down the street, totally minding my own business, and a total stranger comes from behind me and strikes me and injures me, I think that person should pay for all the medical bills, and that person should maybe go to jail for 30 days, okay, at least. And if I bring charges that way, it could be in civil, he can be put in civil jail, okay, not necessarily criminal, but if I bring charges, I suspect that most jurors would roll with that one, okay. But the law comes from the sovereign. You decree it. That makes it the law of the case. If you don't decree it, you don't have the law. Now, if you fail to decree it, then what happens is that maybe the judge might invoke it. I don't know. It's or whatever. They work it out. But that's for people who don't understand they're in charge. But if you're in charge, you must decree what the law is before you can run the rest of your case. All right, but where do you find this law? Well, you make it up. But I try to make my law, with the exception of the pink shoe law, I try to make my laws pretty well meet the existing pattern of statutory law. I borrow their wording, but it's my authority that makes it a go. Okay? That's why it said, you saw it there, the law of this case is decreed as follows. And my signature is at the bottom of the paper. Okay? So that's where the law comes from. But you have to be instructed by reason. If you want an example for everything you do, believe me, this is not going to work for you. All right? It won't work.